position says the Fourth Amendment does protect that. But if the question is whether the Eighth Amendment forbids a certain application of the death penalty, he's not looking at cruel and unusual punishment, which our understanding of may change over time. Why is it that most of us today think lopping off ears would be unacceptable, but that, you know, we may disagree among ourselves about the death penalty, but we disagree about that. So I think Scalia is manipulating the level of generality at which he takes the original understanding. With the Fourth Amendment, he's not willing to say, did the framers have any idea about this technology? If not, then it's permitted. With the Eighth Amendment, he wants to look very specifically, did they execute people? If they did, end of the debate. Now think about another example where I think this particular example, he's manipulating the categories himself. Scalia's position on whether the government could, what counts as an impermissible mixture of church and state. Right? Scalia's position is, of course you ought to have prayer in school. Of course, the 19th century, nobody had a problem with that, which is true. But his position is also, it has to be a non-denominational prayer. It can't be a Christian prayer which excludes Jews. Well, that's exactly what they had in the 19th century, right? They had Protestant prayer, hymns singing, they had Protestant Bible reading, they hated Catholics, they didn't think much of Jews. Scalia is being inconsistent, manipulating the level of generality, because he knows nobody today would be very comfortable with the idea that it's okay to have school prayer and it's okay to do it in a way that makes Catholics and Jews and Hindus and Muslims feel uncomfortable. So he's trying to have it both ways, and that's what translationists are always trying to do, because if they don't, their position seems really unpalatable. At least that's what I think.
Yes. A question for Professor Meese. We heard a lot of concessions from Professor Klarman about the sort of virtues of originalism, and I was wondering if you could maybe if you would point out what you think some originalism bounds are, and in situations where translation, to borrow one of Professor Klarman's words, does fail, if you can think of any, where does that leave an originalist? Notwithstanding that you think that there aren't really many other useful models, is like constitutional amendment the only sort of resort, or like what would you do in a situation? You can think of a situation.
Well, I mean, let's say that one were to concede that in some cases an original meaning methodology produces indeterminate results, right? You just can't decide how to apply this provision. One response might be, and this is the 19th century response, the statute is presumed constitutional unless somebody who's challenging the statute bears their burden of proving that the statute is inconsistent with the Constitution. And if they can't bear that burden of persuasion, then they lose and the statute is constitutional, right? So one way courts have often solved that problem is by saying there's a presumption of constitutionality. Even today, the Supreme Court still claims there's a presumption of constitutionality. I don't think they really think that there is, but they claim that there is. And that's one way of solving that problem, right? Of indeterminacy, right? That somebody has to actually prove that there's a meaning here that the statute is violated. Now, that takes a kind of majoritarian default, right? You're saying, well, I think the democracy is great, and the majoritarian process generally produces good results, unless you can really prove to me that the thing consistent with the Constitution. A libertarian can take the opposite approach and say, well, no. What really matters here is, was there authority delegated to the government to do this? And if the result is indeterminate, then the individual wins as against the state, right? So you would need to put a meta theory to decide between those two presumptions. And I'm not sure how one would derive that meta theory. But those are sort of two competing ways of dealing with the problem of constitutional indeterminacy. But may I add that, yes, we can always point to indeterminate results. We can point to problems with application of the Eighth Amendment, although the death penalty is plainly constitutional for various reasons. That's true. When we're talking about what Carl Llewellyn called, I think, was it automobile collision cases, right, where the vast majority of human activity does not result in an automobile collision. Some human activity does, and so 1/2 of 1% of the activity is what we end up arguing about. That's what produces cases. But 99.95% of governmental activity is plainly governed one way or another by the Constitution. It's absolutely clear what the government can or can't do in a wide variety of cases, and law professors and judges end up arguing over the fringes. And the fringes, by definition, are always going to be hard cases, and therefore look like we have a lot more indeterminacy than in the real world we really have. So I go back to, if you're really a non-originalist, do you throw out all the rules in the text on everything? Professor Klarman won't do that. No non-originalist will do that. Right? So we say, well, originalists don't really adhere to their position when it's hard to do so. The same is true of non-originalists. They all agree, as Professor Klarman said, Delaware gets 2 senators. There's no justification for that whatsoever. And I'm not
I disagree with that.
No,
I was happy to take away.
well, you are, but no judges, right? You know, Breyer would never say that, or even Brennan wouldn't say that, right? Just like you said, it's fine for a law professor to say something when a judge says it. Well, a law professor can say get rid of Delaware senators, but no judge would do that. No judge would ever do that.
I just want to, I can't fail to note the irony that the 2 meta principles that Alan invokes to resolve the cases of indeterminacy, one is democracy and the other is libertarianism. The framers were neither of those. The founding generation despised democracy. Every state had property qualifications for voting. The only reason they didn't put it in the Constitution is because you could never have agreed at what the level of property qualification should be. The framers said behind the closed doors of the Philadelphia Convention, democracy is a dirty word. We don't want rule by the mob. And in terms of libertarianism, they weren't. I mean, they had no problem punishing fornication, throwing people in jail for blasphemy. You know, it's a big mistake to read in the sort of 19th century economic libertarianism back into the founding generation. They just weren't that libertarian. They had no problem with the state telling people how to run their lives in a way that you and I would be appalled by. So you're really not getting either libertarianism or democracy from the original understanding. Those are
if I may, Mike, I mean, the state was far smaller in 1790.
The national government was. I don't know that state governments were. They regulated all sorts of details of people's life. You couldn't cut down trees on your property because there was an ancient right in the crown to maintain forests on your land. They were very pre-capitalist in many ways.
I'm going to, in light of the time, I'm going to exercise the moderator's privilege to ask the final question, and then if others have things they'd like to address to Mike and Alan, come down and speak to them. My final question is this. Under an originalist interpretation of the Constitution, does the Constitution of the United States permit a woman to serve as president?
Oh God, there's probably some text you're going to point out.
Article 2, I believe, uses the masculine pronoun in describing the president. Surely an original understanding would be there'd be no contemplation that the president would be any gender other than male. Is that?
I got this one. I got it. Can I go first?
You can take the last
okay.
word.
All right. Here, look, I have to read that provision. But, you know, it's often the case, and probably until 20 years ago, when we used the pronoun he, right, that could be a generic, right? Just as sometimes we refer to men, and that's a generic to refer to men and women.
So
right?
you assert framers were using he in a gender-neutral way.
For instance, I remember in Latin, if you have 100 people and one of them is male and 99 are female, you would still use the masculine ending for the adjective to describe that group of people. Not because they're all masculine, right? You recognize that a lot of them might be women, but you would still refer to them as male. Well, that's inappropriate, right? But that doesn't mean that the use of the word he as a pronoun necessarily is intended to exclude women. Now, I don't know any more about the original meaning evidence of that particular thing.
Thank you very much.